Item number 1.
Opposition affidavit, and I would like to argue on only 5 major points.
But before my friend begins, my lord, this is a matter with regard to release of seized gold, my lord. Lordship. But here what happened, my lord?
You can't identify the gold.
We cannot add because it has been deposited with the Reserve Bank of India, my lord. And this aspect was not brought to the notice of learned single judge also, and before this honorable court also at that point of time. So
This is very vital.
That's a very important fact, my lord. I admit that, my lord.
What is to be done, Mr. Counsel?
Because I have 5 major points. I'll just give the brief of those. My lordship and then decide this condemnation delay application is liable to be dismissed on 5 major points. These are
No, Mr. Chadda, Mr. Chadda, you say this, that suppose we condone the delay. What is to be done if the gold is not there?
They are admitting the fact that they want to give the amount, refund the amount of the value of the gold, but the amount what they are going to give is at the time they seized. But today, as in today, if the gold was in my possession, it would have had that value. So that is the dispute as of date.
No, when you were entitled to its possession, which date?
18th, initially by the order passed by the learned single judge on 5th of April 2024. Thereafter, they challenged this order and they came into a writ appeal.
No, I think the tribunal directed
No, my lord. No, my lord.
handing over of the gold.
The learned single judge.
My lordship,
They came to a writ petition with honorable court, my lord.
writ petition was filed for the return of the gold and it was decided in 5th of April 2024. Thereafter, they challenged that order and this honorable court passed an order on 18th of February 2025. So as on last order was 18th of February 2025, which the lordship have himself passed an order in division bench, and accordingly they were supposed to return the goods within 4 weeks. And they did not comply with the order, and they are still. The contempt petition is still pending before the learned trial court.
But here what happened, my lord, after the order passed by, when the writ petition was pending, my lord, adjudication order has been passed by the department, my lord, confiscating the gold. So otherwise also they don't have any right over that gold, my lord. Because once
That
is under challenge.
The order passed by this honorable court.
This confiscation order was ultimately set aside.
No, my lord, the department has adjudicated the matter, my lord. Confiscation order has been passed, saying that this is a smuggled gold, my lord. So ultimately, of course, they filed, they submitted, they filed.
We have filed an appeal for that, and it is.
So appeal is pending, my lord. So, my lord, the appellate tribunal can take a decision in this matter, my lord, if lordship permit.
Well, lordship, as far as this honorable court's order is valid and really binding on them, they cannot go escape that order. What was the purpose of this honorable court passing an order if they are not complying with the same?
Or alternative, my lordship made on the first occasion, on the last hearing, lordship was a tentative view, my lord. That
No, what was the value of the gold on 18th February 2025?
It was somewhere around, Lord, 20 lakh of rupees.
How much are they
21
offering
lakhs.
now?
They are offering only roughly 10 lakhs.
10,72,000.
So, if you got the gold on 18th February 2025, the value was
Yes, my lord.
Around 21
lakhs.
21 lakhs.
Yes, my lord. Yes, my lord.
That value you could have obtained by disposing the gold in the market, in the open market.
I could have disposed
right.
of, my lordship.
And-
Even if I would have retained it, That value
all
was
right.
with me.
And you could have earned interest on that 20 lakhs, say at the bank's lending rate. Say, let us put it at 10%. So you take 20 lakhs plus 10%.
11 lakh plus 10%, my lord.
Huh?
We're really
11
happy with
plus
this.
10%.
No. The
20 lakh is the present value, my lord.
it was the value on 18th February 2025.
February. Yes, Lord. We'll be more than happy with this order.
My lord, what I'm submitting, this,
Had it been returned on time, he would have had use of the gold at that point of time, which was 20 lakhs.
my lord.
Now, let us say he has gold worth 20 lakhs. Now, at that point of time, your responsibility stops. Now, if he would have sold the gold and say invested the money in a deposit, he could have earned about 7 to 8% on it.
But what I'm submitting, well, there is a confiscation order. That will make a lot of difference, my lord. Because ultimately, once confiscation order is there and he gets it set aside by a higher tribunal, my lord, he is liable to return the gold to the department, my lord. So he has
But
to
where
return
is the gold? The order was you have to return the gold.
My lord.
Then you enforce your confiscation order. But where is the gold?
Because when we
Now, if you can't give the gold,
My
you
lord.
have to give the value on 18th February 2025.
my lord, what we are saying, my lord, way back we have deposited the gold with the Reserve Bank of India, my lord. We obtain only that much value, my lord, or 11 lakh rupees only. Now, so subsequent escalation in market price, my lord, that was not in our hand, my lord.
And
Then-
that is contrary to law. They haven't complied with the law as per Section 150 of the Customs Act. They cannot dispose of the gold without giving notice and without the consent of the owner of the gold, of the property. If the gold has not been, so long as the show cause notice was also not issued at that time when they have disposed it of. Section 150 is very clear about it, Lord. If my lordship may allow me, I will just read the section.
Appeal is pending.
Their appeal is pending.
Yes, my lord.
Against the confiscation order, appeal is pending.
Before the High Court.
Before the tribunal, I believe.
No,
Mr.
my lord.
Chadha?
It is before the Commissioner of Customs Appeals.
Let him deposit 22 lakhs in your name, your client's name. But
Yes, ma'am.
you don't encash that amount. You have to keep it in deposit. Pending
Yes, my
the
lord.
decision by the Commissioner Appeals.
Well,
You can't use that money.
Lordship, I would just request one thing. I can give an undertaking. Whatever will be the outcome of the finality of this case, we will comply with the same, but that amount will be allowed to be used. Because
But
if
then,
he doesn't allow,
you should furnish a counter bank guarantee if you use that
Lordship,
money.
instead of a bank guarantee, we can give an undertaking, Lordship, because
Well, an
it was only
undertaking
for
is-
domestic use. It was for
They'll ask her
domestic
to
use.
file a money suit, my
He is
lord.
not a businessman. He was just simply wearing a gold kada. So, my lordship, is this not a trade deal where he can give a bank guarantee, my lordship? We will give an undertaking for the same, my lord.
Undertaking where?
Before the customs, we give an affidavit.
You give a suitable security before the Commissioner Appeals.
My lordship,
You
security
put money
will
in
then again
deposit?
turn into,
And
we will not,
such security as the Commissioner Appeals may require, you furnish that security and take the money.
my lordship, they would require the entire amount. It's very difficult that amount. If they were supposed to give me that gold kada, I would have been using it. Now, if this order is passed, in this case, I will not be.
You
enjoying
would
the
not have
benefit
been
of
able
the
to
gold
use it
kada.
because it is immediately followed by a confiscation order.
My lordship, they have passed an order, but this
No,
appeal is still pending.
Unless that confiscation order is vacated or modified or set aside,
I have a submission, my lords, on this. I have a submission. Initially, they were there. I just want only 5 points to be submitted before this honorable court. The first violation, what they did is, first gross negligence and ignorance was that they did not give the show cause notice within time. Second was the Honorable High Court single judge passed an order, they did not comply with it. Then, My Lordship, the division bench of this Honorable Court passed an order, they did not comply with it. They disposed of the gold without issuing the show cause notice, which is against section 150. I will just read section 150 for a moment, My Lord. I'll just satisfy this Honorable Court. My Lord, section 150 says the procedure for sale of goods and applications of sale proceeds. It says, My Lord, when any goods not being confiscated goods, when any goods not being confiscated goods are to be sold under any provision of this Act, they shall, after notice to the owner thereof, be sold by public auction or by tender or with the consent of the owner in any other manner. So, My Lordship, at that particular time when they have disposed it off, they did not take consent, they did not inform, and they disposed it off. That is bad in law. And there is a judgment of Bombay High Court in this, My Lord. I have enclosed in my review the counter to my review petition. The Bombay judgment says,
My Lord, I am not going to merit, My Lord. To cut short the matter, My Lord, your Lordship directs us to deposit the present value, My Lord, with the Commissioner, and let Commissioner deal with that in accordance with.
We will be bound
by giving some kind of security
deposit. The objective of going in writ petition, objective before this Honorable Court will defeat if we are again handing over that amount in their hands. The order was to return the gold. And the law says,
My Lord, they are totally legalistic, My Lord. What will happen, My Lord? What will happen?
Now they are in violation and I am being punished for the same.
But ultimately, who has smuggled the gold, My Lord? As it stands in
it is a matter of subject
even
of
if your commissioner
My Lord,
upholds the confiscation order,
My Lord,
what is to be confiscated? Money?
money is to be confiscated, My Lord.
No. How can money be confiscated? It's only illegally imported goods which are confiscated.
No, My Lord, when the illegally imported goods is released, My Lord, in that case, in such case, My Lord, if he disposes of the article, My Lord, he has to pay back the money.
You have any immovable property in your name?
movable property. I'll have to check. I have to seek instructions
Immovable.
from my client. I'll have to seek instructions, My Lord.
By when? By day after tomorrow?
Maybe yes, My Lord.
All right.
Yeah.
My Lordship, one more submission. If My Lordship is inclined to condone the delay, I'm ready to argue with the review petition. And on merits, My Lordship, this case does not stand, My Lord. The reason being, My Lordship, I'll just give one submission. They have disposed of this gold only on their instructions from the customs circular they have enclosed in the application. It is not applicable in my case because it is only applicable for gold or gold jewelry pertaining to 24 carat. And in my case, the gold jewelry was less than 24 carat. So in that case, they were not liable. They had no authority to sell that gold. The instructions which they are relying upon is not binding on me.
How many days did it?
134 days.
All right. Condonation of delay application. Sufficient causes shown. We condone the delay of 124 days in filing the application for review of our order dated
18/2/25. 18/2/25.
18 February 2025. The application for condonation of delay under Section 5 of the Limitation Act is allowed. List the application for review for hearing on 28th August.
Well,
We will hear it on 30th. Saturday is all right?
Yes, My Lord.
Saturday is a
Yes, Lord.
compensatory working day here.
Yes, My Lord. I'm ready.
Well,
On 30th,
It's okay, My Lord.
as the only matter in the list. There will be only one matter.
Grateful, My Lord. Grateful.
deep.
Just put this one matter on second.
Please, Lordship, in view of the order dated 18/8/2025, I have tried to serve this memo of appeal to the earlier advocate who was appearing the writ petition, but he has refused. Then again, I have taken an initiative to send to the private respondent by postal service, Lordship. Therefore, still that service is still awaiting.
Respondent number 5 you have served.
We have served to the advocate, but advocate who is appearing earlier, he refused to accept. He said that maybe they might have
So that was the story last time also. You were asked to serve on the respondent.
Yes, now
number
we have again we submit through post office. Still, it is awaiting. We have taken the initiative. We have already served. It is still awaiting, Lordship, through postal service, Lordship. It's done. So
This appeared an application on 2nd September to enable advocate on record for the appellant to file an affidavit of service showing service on the respondent number 5.
For 1 to 4. And for the state respondent, my lord, 1 to 4.
Lordship,
Mr. Sudhir will appear.
may I make a small submission, Your Lordship? This petition actually, that order was, it says there is a error in that order because there is a bar by section 10 and 11 of that.
You first serve and come.
Till that, Lordship, this impugn order may be stayed because they will release the money.
No, you have to serve. You are not effecting service and
The
how can
government is.
the order is against the government.
He is appearing for the government. 1 to 4. They are the
Not for
main respondent.
private
They are the main respondent.
5 is the
5 is the private respondent.
Now, what happened is this same case, same subject matter, same party is still pending in the court of district
yes,
council.
but it concerns the private
No,
respondent.
my lord, this is regarding the pension, my lord.
Of the
this-
private
that's-
respondent.
No, I'm for the state, my lord.
It concerns the private respondent.
Yes, my lord.
Then, without serving him, how can we pass an order? You come on the second.
Lordship. Much for Lordship.
Number 3.
My lord, this pertains to the plastics ban, my lord. This part, they have, the respondents have, I must admit, my lord, candidly, the respondents have done a substantial work, my lord, in this. And very striking things apart from seizing, raiding, they have also done one very nice thing, I must admit, my lord. There's a rhyme of 7 hours, my lord. Rhymes of 7 hours. And this will go a long way, my lord. But this strategy, my lord, must be, if they adopt, my lord, in a very frequent manner, my lord. Page 99 of the last report, my lord, there's a my lord has page 99, my lord.
Yes.
The last report, my lord. I'll just read the first paragraph, my lord. Objective. That's called rhyme of the 7 hours, my lord. A post-evaluation report. Objective. To bring the people of Meghalaya together and work towards a more sustainable future. This initiative aimed to foster a collective consciousness centered on responsible waste management. At its core lies the goal of raising awareness and inspiring action through the principle of 7 R's. That is, rethink, reuse, reduce, reuse, repair, regift, and recycle. So, my lord, execution. They have done this execution, my lord, from 17th May 2025, culminating on 9th June 2025, making a three-week long campaign, my lord. So it's a very good initiative. But if this can be carried on, my lord, in a regular basis, this will go a long way, my lord.
What about action in the other districts?
All the districts, Lordship, we have submitted a report.
This is for East Jaintia.
This East Giant Hill was the only one left, Your Lordship, and we have submitted on the last date. And East Khasi Hills, Your Lordship, this is a supplementary action report. Now, this is an ongoing process, and all the districts are taking active part in bringing about a ban on this single-use plastic and bringing it about an
And
awareness.
other districts?
Other districts, it is already submitted, Your Lordship. Huh?
What districts?
Your Lordship, we filed it on the 24th of June 2025, Your Lordship. District-wise reports in compliance with the orders of this Honorable Court dated 14th May 2025. East Giantia Hills had not submitted, so we have submitted this on the last date, and this is another supplementary action taken report by East Khasi Hills.
So we are disposing of the PIL?
Oh, my lord, my lord.
Dispose it of.
Please take to. this public interest litigation was about banning or checking the use of plastic. Full stop. Its indiscriminate use. Posed a threat to the purity of the environment. Full stop. Used plastic products less than 120 microns. Also termed as single-use plastic, was most dangerous. Full stop. Apart from causing ugliness in public places. No, cut it out. Apart from its deposit in public places causing ugliness. Use plastic was very difficult. Use plastic is very difficult. To destroy. Or recycle. Full stop. These products tended to block the drainage system. Of the surrounding area. Paragraph. By several earlier orders, this court had directed that the public, the members of the public, should be made aware of the dangers of plastic use, comma, prevented as far as possible from, no, prevented from using plastic of less than 120 microns. Full stop. By our orders, we had also directed action so that plastic over 120 microns could not be brought into this state for sale. Whatever he said, Mr. Lam? Stop. Furthermore, those products over 120 microns were to be seized and destroyed. Full stop. We are happy to state that the administration had rendered all cooperation in implementation of our orders. Lastly, on 14th August 2025, we had directed an action taken report for East Jantia Hills District. And a supplementary action taken report for, I've said East Jantia Hills and East Khasi Hills to be filed. Such reports have been filed by Mrs. Yangi, Additional Advocate General. The writ petitioner, Mr. Fuyosa Yobin, appearing in person, was given an opportunity to peruse the reports. He submitted before the court today that he is fully satisfied with the action taken by the state, namely in making the people aware of the bad effects of plastic and taking measures to stop use of single-use plastic less than 120 microns. Paragraph. We accept the submission of Mrs. Yangi that similar effective action has been taken in the other districts. We direct the state administration to continue its awareness program and its action of stopping the procurement, sale, and use of plastic less than 120 microns. The public interest litigation is thus disposed of.
I am deeply obliged, my
With
lord.
liberty to apply with a fresh
My lord.
application, even when any breach of the orders of court
My lord.
is which of the orders of this court occurs, full stop.
My lord, I'm grateful, my lord.
Oblige, Your Lordships.
Number 4.
May we please, Your Lordship?
Yes,
Lordship, I beg to inform this Honourable Court that the clients they want to engage a new senior counsel, Your Lordship, in this case.
Yes.
In this case, Your Lordship, the clients they want to engage a new senior counsel since the conducting counsel is on, he's not, he's sick, Your Lordship.
fixed for hearing.
Yes, Your
You have to
Lordship.
finish the matter.
So they've taken the brief also, Your Lordship.
When?
Lordship, if after 3 weeks, Your Lordship, 3 weeks.
It takes 2 hours for counsel to get ready. As a last chance, this criminal appeal is adjourned till 2nd September. Mr. Khan, it's all right.
Right, Your Lordship.
To enable the appellant to engage a new counsel to argue the matter
Yes, Your
in
Lordship.
court.
Right, Your Lordship.
So, Lordship, in that view, the matter, because since the council have recused themselves, maybe notice has to go, Lordship. Otherwise, how would the council, how would the client know that matter is fixed?
No, no.
Could be a technical issue on second, except if they undertake to inform the council.
No, we'll inform Your Lordship, the counsel.
Inform the
So if they inform the client and then they know the date on 2nd September, they engage a counsel, things will be different. Otherwise, normal procedure would be they
but
have
his client is engaging the counsel.
Yes, Your Lordship.
but their submission is that they have recused themselves from the case,
we've
they
not
returned the
said-
file.
No, Your Lordship. The clients, they'll be engaging a new counsel, Your Lordship. So they've come and taking the file away, Your Lordship, to engage a new senior counsel. So I'll inform the clients, Your Lordship, on 2nd September.
Wakalatamas filed in criminal appeals.
Lordship, yes.
So let him file a
If he engages, if he informs,
I'll inform Your Lordship. I'll undertake that. I'll inform them.
Your Lordship, then it's okay.
What is your name?
Emling Your Lordship.
Yes, you give your name. So and so appearing for the appellant undertakes to this court to inform the appellant of this order.
Yes, Your Lordship.
Yes.
Obliging.
Oblige, Your Lordship.
5 to 7.
7.
Now you take down this order in this way. Submission is made on behalf of the appellant that the counsel appearing in the matter
Told the judge, yeah?
has expressed his inability to appear any further, and that a new counsel would be, new senior counsel would be engaged on behalf of the appellant. Then, as a last chance, that this matter was adjourned earlier. Next, as a last chance, we fix this matter on
26th August.
2nd September. Advocate on record for the appellant. Is at liberty to file a fresh vakalatnama if the circumstances so warrant, and inform the appellant of the gist of this order. Yes, please.
May it please, Your Lordship.
Affidavit has been filed as per your lordship's liberty, given to the other side.
May it please your Lordship.
1 minute.
Lordship, the challenge, my Lord, I will argue from the lead matter because the papers are common and everything is common, my Lord. The challenge before your Lordship is to the two amendments which have been carried out to the Meghalaya bonded warehouse rules and excise rules, my Lord. Now, I wanted to place, my Lord, the exact terms of the bonded warehouse amendment rules and excise amendment rules, my Lord. And then thereafter, I wanted to demonstrate, my Lord, that the amendments have been carried out in exercise of power vested in the state government under the Excise Act, my Lord. And there are enough checks and balance in the delegated legislation, my Lord, which protects the right of the petitioner and also bonded warehouse and central bonded warehouse. Your Lordship, kindly see the amendment into the bonded warehouse rules, my Lord, which is at page 43 of the paper book, my Lord. This is, the Lordship will notice, this is 15th October 2020 notification amending the Meghalaya Bonded Warehouse Rules 1965. Now the amendment, if your Lordship will notice, which is subject of challenge
Yes.
before your Lordship is small Roman 2A, my Lord. Now, insertion of new clause small 2 Roman 2A in Rule 2 in the principal rules in Rule 2 after the existing clause small Roman 2, the following new clause shall be inserted, namely, central bonded warehouse means licensed central warehouse where IMFL, beer, wine, BIO, etc. imported on pre-payment of excise or ad valorem import pass fee, transport pass fee or license fee are kept for eventual removal to bonded warehouse as provided for Meghalaya bonded warehouse rules and all its extant rules. So, and by amendment, my Lord, what has been created by small Roman 2A is central bonded warehouse, my Lord. Under the original rules, my Lord, if your Lordship will have a look on the excise manual on this part, my Lord, under the original rules, my Lord.
Excise manual.
Yes. The state government, in exercise of power under 36 of the Excise Act, my Lord, has already created bonded warehouse, my Lord. That excise manual, your Lordship, will kindly come to page 177. at the foot of the at the bottom, my Lord, page numbers are there. Page 177 up the top of the page also there is both this one. Under 77 is the Assam bonded warehouse rules, which has been adopted by state of Meghalaya, my Lord. And kindly come to Rule 2, sub-rule small Roman 2, my Lord. Bonded warehouse means the premise or any part of the premise approved and licensed for deposit or storage of a spirit on which duty has not been paid. So under the Excise Act, my Lord, my submission is that the state government has power to create bonded warehouse. State government, by exercising the same power, my Lord, has created central bonded warehouse by inserting a small Roman 2A, my Lord. There is no challenge, my Lord. There is no challenge to the power of the state government to create bonded warehouse, my Lord. The issue before your Lordship is that they are saying that by creating central bonded warehouse, we have ultra-wires the provisions of the Excise Act, my Lord. if a state government is vested with the power to create bonded warehouse, my lord, it has also the power to create central bonded warehouse. The fact that the bonded warehouse have been created under the Act and there is no challenge, my lord, it squarely applies to the principle, my lord, that the state government has power to create central bonded warehouse also. Because the entire argument of the petitioner is, my lord, that we do not have power to create central bonded warehouse. But at the same time, the petitioner is accepting that the state government has power to create bonded warehouse. If we have power to create bonded warehouse, we do have the power to create central bonded warehouse. There is no question, my lord, as to the power of the state government to create bonded warehouse. And bonded warehouse will do what, my lord? There are certain powers conferred on them. And kindly now read the definition of the definition given to central bonded warehouse at small Roman 2a, my lord, at page 43 of the amended rules, my lord. 43 of the writ petition, my lord. Page 43 of the writ petition. At 43, my lord, kindly come to amendment number 2, insertion of new clause, small Roman 2a, in rule 2. In the principal rule in rule 2, after the existing clause small 2, the following new clause shall be inserted, namely central bonded warehouse.
You have shown this.
Yes, my lord. So the point I was making after showing the 2a original, my lord, that 2a small Roman 2 provided for creation of bonded warehouse. And small Roman 2a provides for creation of central bonded warehouse. And the entire case of the petitioner is that I do not have power to create central bonded warehouse, but they are saying that I have power to create bonded warehouse as there is no challenge, my lord. So therefore, their entire arguments falls flat on this premise only, my lord, that if the government has power to create bonded warehouse, it has got power to create central bonded warehouse, and it has got power to create more than one central bonded warehouse. Now kindly see the provisions which are applicable to central bonded warehouse in the amendment rules, which are a kind of check and balance on the powers of the central bonded warehouse, which has been inserted by inserting rule 44 on the same page 43, my lord. Kindly see rule 44 at page 43, my lord, which creates certain checks and balance on the exercise of power by the central bonded warehouse. So to say that the powers exercised by central bonded warehouse are unfettered, my lord, in my humble submission is not wrong according to me, my lord. Kindly see the fetters which have been put, or the restrictions or regulations which have been placed on central bonded warehouse by inserting rule 44, my lord. Kindly see at page 43. A license to establish and work as central bonded warehouse in the designated area on prior approval of government shall be sued by the Commissioner of Excise on following conditions, my lord. Selection for license to establish and work a central bonded warehouse in the state shall be based on competitive bidding process open to individuals, partnership firms, companies, etc. The base fee for license to operate a central bonded warehouse shall be 1,50,000 rupees only annually as fixed by the government from time to time. So 1,50,00,000 lakh is the license fee which the central bonded warehouse is required to pay. Tenure of the license shall be for 10 years. Excise Commissioner reserves the right to extend it, my lord. Now after this, my lord, kindly see clause 6. What are the restrictions which we have placed, my lord, and what kind of fetters we have put in on central bonded warehouse? Shall operate on a plot of land measuring not less than 1,50,000, my lord. 7. Central bonded warehouse must construct warehouse where to hold at least 6 lakh cases of Now eligibility is 8, my lord. Central bonded warehouse shall be eligible to supply only to the bonded warehouse located within the state. 9, the central bonded warehouse shall have capacity to supply and deliver all registered brand of IMFL, beer, wine, BIO to the bonded warehouse within 45 days of goods produced in the state and 60 days for goods imported from outside the state. Central bonded warehouse shall have minimum stock, my lord. That is 10. 11 must be operational. And then, my lord, 12, minimum profit margin eligible for bonded warehouse on their sale to retail IMFL off and on licenses shall be 8% of IMFL brands on except bottle in origin. So minimum guarantee has also been provided to the bonded warehouse, my lord. And 13, my lord, central bonded warehouse or ex-bond rates for all imported goods shall be subject to approval of Commissioner of Excise during the course of annual registration of brand. So, my lord, 13 is one of the most important check on their power to demand commission, my lord, because prices of the all brands will be fixed by the commissioner, my lord. Kindly see 13. It's not that they have the unfettered right to fix the price of the product, my lord. Central bonded warehouse or ex-bond rates of all imported goods shall be subject to approval of Commissioner of Excise during course of annual registration of brand. So this...
But where is your protection against discrimination by central warehouse with
the other
bonded...
yes, my lord. Now kindly see, my lord, this is also there. If your lordship will see the clause 9, my lord, clause 9 of this license only. Central bonded shall have the capacity to supply, deliver all the registered brands of IMFL. So all registered brand of the supplier and manufacturers they have to have the capacity. If they do not supply, my lord, I have the power to cancel the license. This is one of the conditions of the license. This is one of the conditions of the license because 9 itself says, rules 9 itself says, my lord, capacity to supply and deliver all the registered brands of IMFL.
Suppose they favor one bonded warehouse against another?
No, what the system is, my lord, if I place it, my lord, the manufacturer comes at the apex level, my lord. After that, manufacturers will suppliers will approach the state government where they will get all brands registered. After registration, central bonded warehouse will place the order on the brands, my lord. Now, there are 45 bonded warehouse here, my lord. Now, 45 bonded warehouse, they go to the central bonded warehouse only through the state government because for transportation of the liquor, they have to take permission because they cannot, even bonded warehouse will have to place indent on the state government saying that I require a particular brand from central bonded warehouse for which you give me transport permission, my lord. The state government will give transport permission, state government will collect the duties and those permissions will go to the central bonded warehouse. From central bonded warehouse, it has to go to the bonded warehouse. So there is an additional check. It's not that central bonded warehouse or will have right to directly deal with the bonded warehouse. First, indent has to come to the state government, my lord, for getting the permission, my lord. So therefore, and in the entire writ petition, my lord, even bonded warehouse has not made a single averment that there is a discrimination between supply by central bonded warehouse to the bonded warehouse. It is not their case, my lord, that there is a discrimination or rules are obstructing or giving the extra weightage or power to the central bonded warehouse to pick and choose bonded warehouse, my lord. So therefore, that apprehension, my lord, is absolutely, in my humble submission, unfounded. There is no averment and there are checks and balances where if there is any, because it's not a case where bonded warehouse will place the order directly to the central bonded warehouse. For every order, the bonded warehouse will have to come to the central bonded warehouse.
Where is 44? Rule 44?
Rule 44, your lordship will find at page 43. And kindly see, where is that line? 44.9, my lord, kindly see, 44.9 is also making it clear. The duty and responsibility. Page 44, my lord. Page 44 and subclause 9, my lord. Subclause 9, my lord.
Yes.
The central bonded warehouse shall have the capacity to supply all the registered brands of IMFL, beer, wine, BIU to the bonded warehouse within 45 days for goods produced in the state and 60 days for goods imported from the outside the state. So there is a mandate on the central bonded warehouse to honor the indents of bonded warehouse. And 10 also, my lord, is another additional check on central power of the central bond. The central bonded warehouse shall have a minimum stock of all types of brands for 3 months at a point of time so that continuous regular supply can be maintained for all bonded warehouse throughout the state, my lord. So 9 and 10, my lord, in my humble submission, are sufficient protection to the bonded warehouse, and not a single case has come where the bonded warehouse has complained that I placed the order and I did not get it, my lord. So therefore, my lord, the powers which we have exercised under the Excise Act under section 36, my lord, is very clear. That power gives me to amend the rules. These rules have been your lordship has seen, these rules have been framed in the exercise of power under section 36 of Meghalaya Excise Act, my lord. Now, this is the first challenge. This is the challenge to the amendment to these Meghalaya bonded warehouse rules, my lord. And then the second rule which is under challenge is, my lord, before your lordship, virus of these rules are under challenge, is at page 46, my lord. And your lordship will see amendment to rule 3, page 46. In principal rules, rule 3 and sub rule 2, for the words bonded warehouse, the central bonded warehouse shall be substituted. So the change which has taken place, my lord, in principal rule is that in place of bonded warehouse, central bonded warehouse has come into existence, my lord. And for that, your lordship may kindly see the original rules at page 54, my lord, 54 of the excise rules. What is the change which has taken place after the amendment of original Meghalaya excise rules? Because, my lord, in the proper perspective, my lord, your lordship will find that in the clause 3, rule 3, sub rule 2, C, in place of bonded warehouse, the central bonded warehouse has been inserted, my lord. So, sum and substance and crux of my argument, my lord, is that the earlier we were having power to give exclusive licenses to the bonded warehouse. We have given exclusive licenses to the 40 bonded warehouse. Now we have given the exclusive license to one central bonded warehouse, and second central bonded warehouse we have also created by virtue of our power under the Excise Act and rules amended. Because, my lord, when we have the power to create one bonded warehouse, we have the power to create one central bonded warehouse, we have the power to create more than one, my lord. That is not in doubt, my lord. So if your lordship is fully aware, my lord, that
So how do you say that if we have the power to create one?
Because, my lord, if your lordship will see the section itself, my lord, if I take your lordship to the section 16 of the Excise Act, my lord, kindly see section 16 of the Excise Act, my lord.
Excise Act.
Yes, ma'am. This part of the manual, my lord, kindly come to page 13, my lord. Now, your lordship, kindly see, I wish to place certain provisions of the Act, my lord, because the virus of the delegated legislation is in question, my lord. So therefore, and their first argument is, the legal argument which has been advanced by Learned Senior Counsel is, my lord, that it is beyond the competence of the state government under the Excise Act to create central bonded warehouse, my lord. That is the first argument, my lord. So in that context, my lord, kindly see the first definition. Kindly see the definition of intoxicant at page 6, my lord. Page 6, sub clause 12A, my lord. Your lordship, the definition of intoxicant is subsection 2, section 2, subsection 12A, my lord. It says, my lord, intoxicant means any liquor or intoxicating drug, my lord. So the definition of intoxicant is wide enough to include both liquor and intoxicating drug, my lord. And under 12A, my lord, the IMFL, BIO, all variants of the liquor will come, my lord, within the definition of intoxicant, my lord. Now, second definition is, my lord, liquor at subclause 14. Liquor means intoxicating liquor includes all liquid consisting of containing alcohol, also tari, pachwai in any form, and any substance which the state government by notification declared to be liquor for the purpose of this act, my lord. So intoxicant is defined, my lord. Intoxicant includes both liquor, intoxicating drug, and liquor, my lords. And then, your lordship, kindly come to section 4, my lord, where the power to define country liquor and foreign liquor respectively, my lord, is there. The state government may by notification declare what for the purpose of this act shall be deemed to be country liquor and foreign liquor respectively, provided that where the interest of any other state may be affected on such declarations shall be made with the previous sanction of central government. My lord, this may not be relevant for our purpose, but section 6 is relevant, my lord. Section 6 talks about wholesale and retail sale, my lord. The board may by notification declare with respect to either to the whole of the territories to which act applies or to any local area comprised therein as regards purchasers generally or any specified class of particulars generally for any specified occasion what quantity of any intoxicant shall for the purpose of this act be the limit of sale by retail and sale or wholesale respectively. So this section 6 also, my lord, confers power on the state government. Board has been defined to mean state government in the act, my lord. Section 6 also confers power on the state government to restrict and control the supply of the liquor, intoxicant, which includes liquor and everything. Now coming back to the question, my lord, that which has been raised. If your lordship will kindly see chapter 3, and chapter 3, my lord, which is the source of power for controlling and establishment and import of the liquor in the state of Meghalaya, my lord. Chapter 3 has, my lord, kindly see the heading of the chapter 3.
Page,
my lord, is 11. Section 10. Kindly see chapter 3, my lord, import, export and transport. So, section 10, my lord, it says, my lord, restriction on import. No intoxicant, which will include liquor also, my lord, and IMFL also, BIO, beer, my lord. No intoxicant shall be imported unless the state government has given permission either general or special for its import. The section, my lord, section 10A, which comes under the heading of import, export and transport, my lord. So state government has given permission either general or special for its import. Now by creating central bonded warehouse, permission has been given to the central bonded warehouse to import, my lord, the IMFL, beer, liquor, because it is part of the liquor. And it all further says, my lord, the such condition, if any, as the state government may impose have been satisfied. So those conditions are required to be satisfied. That means you have to get the brand registered, you have to sell it to the bonded warehouse on the rate approved by commissioner, and C, duty, if any, payable under chapter 5 has been paid or bond has been executed for payment thereof. Subsection 1 shall not apply to any article which has been imported or India or liable for importation duties so and so, shall not apply to liquor manufactured in India declared under 42 foreign liquor. So Section 10, my lord, gives ample power to the state government to restrict the import of IMFL and permit the import of IMFL with certain terms and conditions, my lord. Now kindly see section 11, my lord. Because transportation from bonded warehouse to the central bonded warehouse and from manufacturer to the central bonded warehouse is also restricted because transport permit is also required. No intoxicant shall be exported or transported unless the duty, if any, payable under chapter has been paid or a bond has been executed for payment thereof, provided that board may, subject to such condition, if any, things fit to impose, exempt any intoxicant from provisions of the Act. So this confers the kind of exemption power to exempt certain. Now, my lord, 12, my lord, which is important, prohibition of import, export and transport. A state government may by notification prohibit the import or export of any intoxicant into or from the territories to which this act applies or any part thereof, prohibit the transport of any intoxicant. So power to regulate import, my lord. Power to regulate transport. And
No, that is there, but the question is whether it has been exercised unreasonably or not, arbitrarily or
so,
not.
my lord,
In violation of 14, 19, 21.
yes, my lord, the
etc.
question which your lordship is correct.
Mr. Banerjee has argued it in great detail. You have also supplemented that. Anything further to add?
No, my submission, my lord, first submission is, my lord, that the rules have been framed in exercise of delegated legislation under the Act. That the Act confers power on the central state government to import, control, import, regulate, transport, everything, which will also include the power of the central state government to create, my lord, the bonded warehouse, for which I place, my lord, section 16, my lord, and I have power to create more than one bonded warehouse. That is very obvious from reading of section 16, my lord. Kindly see section 16. Establishment or the establishment or licensing of
Yes.
distilleries, breweries.
And there is also a reference to warehouses somewhere.
Yeah,
which I have
in the
noted.
top only, if you also will see, and breweries and warehouses.
Yes.
Warehouses, my lord. My lord, if I have power, your lordship, nobody is questioning my power to create 45 bonded warehouses. If I had power to create only one bonded warehouse, I would not have created 45 bonded warehouses in the whole of state, my lord. So section 16 leaves no scope of doubt, my lord, that we have the power to create bonded warehouses, my lord. If the interpretation of the petitioner is accepted, my lord, then all 44 bonded warehouses have to go, because they cannot survive and exist, my lord. And if your lordship will see, even in General Clauses Act, singular is read as plural, my lord. But here the Act itself says bonded warehouses, my lord. So that is my.
He said,
submission.
your learned counsel,
Yes.
that matter of policy is something specialized.
Yes, my lord.
Expert opinion and intervention is
Yes,
required.
Yes, my lord.
Government perceives the need,
Yes, my lord.
the requirement
Yes, my lord.
of formulating a policy.
Yes, ma'am.
It is done by an expert. So
Yes,
it is
ma'am.
so specialized that the court should not poke its nose into it,
Yes,
because the court knows nothing
Yes, my lord.
about the requirements
Yes, my lord.
of the public
Yes,
or the people, citizens, and the need to formulate and implement a policy somewhere. But if it is unconstitutional, grossly illegal,
Yes.
unfair, arbitrary, discriminatory, etc., then the court will interfere.
Yes, ma'am. That's the parameters. That's the parameter for interference in the policy of the state government, my lord.
Yes. As far as economic policy is concerned, also he said that what is public good and what is good for the trade, say liquor trade, the government will perceive.
Yes.
And in case of implementation of that policy, if there is general good, but then if there is a slight diminution
Yes,
in profit of an individual person,
Yes, my lord.
that will not be taken cognizance of by the court,
Yes, my
but
lord, that's very well
court will see the public good.
Yes, that's why I'm not touching the aspects. I'm only confining myself to the power of the state government to come out with the delegated legislation, because that has been lucidly.
And then lastly, he showed that chart to show that forget loss, there has been paramount gain in
Yes, yes, my
the
lord.
sale and the liquor turnover.
Yes, my lord.
That's in summary,
Yes,
the
that's the sum and substance, and very succinctly put by London Senior Counsel, my lord. Now, what I was saying, my lord, is like, why? Because the state government thinks that I should pay 40% income tax. Somebody should pay 30%. These are so somebody should pay more, somebody should pay less. These are exclusively in the domain where Lordship has always maintained the safe distance from those economic policies, unless it is shown that there is no power in the act, or it is offending Article 14, 19 or 21, my lord. These are the two basic principles or premise on which all delegated legislations are tested, my lord. So I was answering the first issue where the London Senior Counsel of Petitioner said that in section 19, what London Senior Counsel referred to section 19 of Excise Act, saying that under section 19, you do not have power to create exclusive monopoly in respect of IMFL. What I was trying to point out, my lord, under the entire import, export, transport and storage, they are being dealt under chapter 3, not under chapter of section 19. And in chapter 9, section 19, if your lordship will see, uses the expression intoxicating drug. So, giving reference to the expression intoxicating drug, the London Senior Counsel was arguing that, look, it is not intoxicant, because under the section 212A, intoxicant includes both liquor as well as drug. Therefore, you do not have power under section 19. My endeavor was to show that I have power from 11 to 16. I have shown, my lord. I have power to do that. I have power under 36 also, my lord, where exclusively power has been section 36 also, if your lordship will stand.
And also I forgot to add this section 19.
Yes.
That this question of monopoly.
Yes, my lord.
He says that because section 19 says that the government can grant these
Yes, my lord.
domestic, these
Yes, my lord.
liquor
Yes, my lord.
manufacturers
Yes, my lord.
exclusive license over the state or over one area of the state,
Yes.
which means that foreign liquor
Yes.
suppliers, distributors, etc., cannot be granted that.
Yes, ma'am.
Only country liquor
Yes, ma'am.
can be
Yes,
granted.
ma'am. Yes, ma'am.
So he has made an interpretation, cited authorities to
Yes, ma'am.
interpret. Both Mr. Shah and Mr. Banerjee have interpreted that.
Yes, ma'am.
That is one.
Yes,
and
ma'am.
yesterday another issue arose as to whether this creation of a central bonded warehouse
Yes, ma'am.
would at all be called a monopoly.
Yes, madam.
Creation of a monopoly, because monopoly refers to whole
Yes.
control,
Yes, madam.
total control of a particular
Yes,
business,
yes.
from manufacture to sale to distribution to everything,
Yes, madam.
and not something piecemeal.
Yes, madam.
So whether it could at all be called monopoly,
Yes.
or just dealing government intervention with a
Yes.
part of the business,
Yes, madam. Yes, madam.
which does not come under the Article 19 proviso restriction or some other decision of the
Yes,
Supreme
madam.
Court.
No, your lordship is absolutely right on the legal point, my lord. And now, my lord, because we have argued also that when we go through the tender process, we invite everybody to participate in the tender for central bonded warehouse. There are Supreme Court judgment which clearly says that would not amount to monopoly, my lord. I can give those judgments and citations.
But then, while this scheme is running,
Yes, madam.
if it is found that the central bonded warehouse does no work,
So then,
swallows 20% commission,
yes, madam.
strangles
Yes.
the bonded warehouses, then the cause of action might arise.
Yes, madam. Yes, madam. And, my lord, if I
But
submit...
as of now, there is no diminution in profit, there is increase in turnover.
Yes,
So the notification is working constitutionally.
Yes, my lord. and if I may supplement, my lord, now if they were having fear of one entity controlling the entire supply to the bonded warehouse. That fear is also gone now, my lord, when I am creating another entity of central bonded warehouse.
Now, if they start telling one set of bonded warehouses
Yes,
that we will not supply you brand A, B, C, D, but we will supply bonded warehouses M and OP, so that their business is enhanced and their business falls, then we can say that this scheme is not working properly and the government superintendence is poor.
Yes, that you lord. But at the same time, lord, now because there will be healthy competition also when I create two central bonded warehouse for the whole of the state. Because
that we will hear, Mr. Singh.
Yes, my lord. So that is that aspect is there, my lord. And 36, your lordship will kindly see section 36.
Mr. Advocate General, can we continue tomorrow?
Yes, my lord. I will do.
Same. Continues but does not conclude. Huh? Same time? How much time are you likely to take?
10-15 minutes, my lord.
And thereafter?
There are Mr. Mosika is there. Dr. Mosika is there.
And thereafter you?
Yes, sir.
Will not be able to run away.